Talk about getting spanked. The Cook County District Attorney, Kimberly Fox, and related lawyers got spanked repeatedly by a federal district court judge in the Northern District of Illinois, covering Chicago. Wait till you hear this story. Very funny, but kind of pathetic as well. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Terrorist Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. Check it out on Amazon. And if you've read the book, feel free to leave a review on Amazon. Always enjoy hearing what people have to say about my work. All right, folks, so crazy case in the United States District Court for the Northern District of Illinois, that's Chicago. The Schoenthal case is a crazy case in front of Judge Iain Johnston. It's actually quite a good case, but a series of events are quite crazy just recently. We're going to go over that in 1 second. Just to start you up on what the case is about, though. The Schoenthal case is about a Second Amendment challenge brought by the Second Amendment Foundation, among others, to a law that prohibits firearms even if you have a concealed carry permit. It prevents you from carrying guns on public transportation, buses, trains, and the like, even if you have a permit. Which means if you are not wealthy enough to be able to afford a car, for example, and you are relegated to taking public transportation for one reason or another, you are deprived of your right to keep and bear arms. Now, Illinois and Cook County are arguing various things, including that because they own the property, they own this stuff, they get to decide with what, how to function, whether or not they allow guns on it, and so on and so on. There is a set of briefs that have been filed basically on summary judgment as to whether or not this law is constitutional or not. No decision yet, but we'll hear soon. But this crazy set of events is quite entertaining that I'm going to break down in 1 second. Just before we get there, I want to let you know that the judge involved with this case is Judge Iain Johnston. Judge Iain Johnston, he's a Trump appointee. He was a magistrate judge there in Chicago for many years before being elevated to the U.S. District Court. And he is the judge here. Now, what's funny about this case is that this is a case, of course, about sensitive places, a euphemism or political propaganda term for government-mandated gun-free zones, because the state says you can't bring guns on this public transportation like buses and trains and the like. And then there's a lawsuit about it by the Second Amendment Foundation and others. So this really turns on what is the relevant standard for what is a sensitive place. We've talked about this before. We won't get into that in this video particularly, because that's not the purpose of this video. But that's what the fight's about. Now, what happened here is while the summary judgment motions were pending, the U.S. Supreme Court decided the Rahimi case in June of 2024. So as soon as this was decided, which as I've explained to you before, the Rahimi case is very narrow. It really deals with people that have been found to be violent toward other parties or other people. They can be temporarily disarmed. That's all it says. It's very narrow. It doesn't help the anti-gunners out very much, if at all, because, again, even the Second Amendment community doesn't want violent thugs and terrorists to be armed, because they're the ones that basically do stupid stuff and commit violent, terrible crimes that give rise to calls for gun control. So even the Second Amendment community wants bad people who are going to do bad things with guns to be disarmed and or imprisoned. Because again, when they do bad things with guns, it comes back and bites the Second Amendment movement on the butt, because it gives rise to the argument that everyone should be banned from having guns. So with that said, after the Rahimi case was decided, the defendants in this case, including the attorney Kimberly Fox, the Cook County District Attorney, filed a joint motion with the parties asking for a status hearing to ask permission of the District Court, Judge Johnston, to submit supplemental briefing as to how the Rahimi case implicates, if at all, the pending summary judgment motions about sensitive places. And that motion, that joint motion, was filed on July 2nd, right before 4th of July weekend. Okay. On July 8th, Judge Johnston denied the motion for a status conference on the grounds that he didn't think it was necessary. He's like, really, Rahimi doesn't impact anything, so why deal with it? So he denied that request on July 8th. But then Kimberly Fox, district attorney for Cook County, and the other defendants, then filed a motion seeking permission to file supplemental briefing regarding the impact of the United States versus Rahimi on this case of Schoenthal versus Raoul. And again, that was filed on July 9th. Also on July 9th, basically as soon as it was filed, guess what happened? Judge Johnston denied the motion again and says, stop it, come on, I get it. I'm not stupid. I'm aware of Rahimi, but Rahimi has nothing to do with sensitive places. Rahimi deals with a guy who was found to be a violent thug, a credible threat to his ex-girlfriend, could be temporarily disarmed. Of course, as a practical matter, Mr. Rahimi is in prison, so that's all that decision was about. It reaffirmed Bruin, it reaffirmed Heller, it reaffirmed the methodology. It didn't speak to sensitive places at all. So, of course, what's going on here is the anti-gunners in Cook County in the state of Illinois are trying to drag their feet and slow roll all these gun cases because there's ultimate desire that now basically Kamala Harris will become the next president and will get to appoint Supreme Court justices either through a court packing scheme by expanding the Supreme Court or by replacing perhaps Justice Alito or Justice Thomas, two of the older conservatives on the court, with, anti-American, anti-capitalism, anti-gun, anti-freedom, progressive judges. Turn them into the Supreme Court justices and eviscerate the First Amendment, the Second Amendment, and so on. You get the point. And expand the power of government over our lives and turn us into serfs and subjects, or even worse. So that's the goal here. So if you slow roll and drag your feet, that is the goal of all these anti-gun policies and these anti-gun litigants, as far as I can tell. They want to drag their feet as long as possible, hoping that a President Kamala Harris will get to replace the Supreme Court and swap the composition up in the same way and make it more favorable to them. That's the plan. Now, of course, if President Trump is elected, which I think there's a reasonably good chance that can occur, then their plan will falter, and I think we will sweep the board. We will win all these cases if President Trump is reelected. I think we win all the cases we've been talking about for the last couple of years once that happens, because the cases will then be decided by the lower courts promptly, because there'll be no incentive to delay anymore, because even if you could swap out Justice Thomas or Justice Alito, you're going to get a younger version of them with an appointment by President Trump, if that were to occur. And hopefully that does occur in terms of President Trump being elected, because if you support the Second Amendment, obviously President Harris or President Biden has no interest in protecting the right to keep and bear arms. That's very clear. Okay. Now, with that said, getting back to our story here. So Judge Johnston has denied twice requests for supplemental briefing about Rahimi, basically because he's like, Rahimi has no meaning to the sensitive place argument, so don't bother me. Then, having the judge deny these motions twice, what does the defendant Kimberly Fox do, the state attorney for Cook County? She files actually a notice of supplemental authority arguing that Rahimi really helps out the government's case here. She files that on July 23rd, 2024. And what happens? Literally, the judge the very next day writes something that says, stop it. Stop this. This is absurd. He denies the request and he strikes from the record the notice of supplemental authority submitted by the anti-gun defendants. And this is what he writes. It's very powerful and in some ways kind of funny. Listen to what he writes. Judge Johnston, against the anti-gun city of Chicago and the anti-gun defendants in this case. Judge Johnston writes, quote, minute entry before the Honorable Iain Johnston. Miss Fox's notice of supplemental authority is stricken. The court is aware of Rahimi and has already denied 2 motions raised in light of Rahimi. The court is making every effort to issue its opinion in a timely manner, and these filings are hindering those efforts. Please stop. Please stop. literally in a court order. So you got these anti-gun defendants in Chicago literally asking the same request, the same relief 3 times in a matter of a few weeks. And the judge 3 times says, stop doing this. I'm aware of Rahimi. It has no impact on sensitive places because Rahimi deals with a violent thug who was found to be a danger to his girlfriend, and he can be temporarily disarmed under 18 U.S.C. 922G, a federal gun control law. What does this have to do with the price of tea in China? And what does this have to do with government-mandated gun-free zones in Illinois and Chicago? Nothing, other than, of course, it articulates the general methodology of text first, burden shifting to the government, and historical tradition, and that's it. We know that. Because the Rahimi case, as Judge Johnston understands, obviously, the Rahimi case doesn't alter that methodology in any respect. It simply reaffirms it. And here's an example of a Trump judge, Judge Johnston, literally saying 3 times to the anti-gunners, stop wasting my time. I get it. I'm not stupid. I've read Rahimi. I'm familiar with Bruin. I get it. I don't need your additional comments because Rahimi's irrelevant. So, anyway, very entertaining stuff. Rarely do you see this kind of opinions and frustration from a judge against a litigant, but here you have it, and I just thought you might enjoy finding out about how the anti-gunners in Chicago there and Illinois got spanked a little bit by a federal district court judge in the Schoenthal versus Raoul case. And again, when there's a decision in this case involving the sensitive places doctrine, I will, of course, bring that result to you as soon as I hear about it. Okay, folks, hope you learned a little bit something here today. Make sure you subscribe. Don't forget to follow me at X at 4 Boxes Diner. We'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.